Hey everyone, for all of you losing track of days, today is Tuesday, or at least this lesson is for Tuesday. So happy Tuesday. Hopefully you woke up before noon today and you might get outside and get some sun. That's always a good thing. So we are still talking about the judicial branch this week. So we're going to look at some landmark cases that happened so that we can see kind of how um, the judicial branch has shaped the United States a little bit more. So we've looked at now all of the courts, but I would say still the major court rulings that are going to affect your life and that have changed the United States and the shape of our government have been the judicial branch rulings. So of the Supreme Court. I know all of them are judicial branch rulings. So the ones from the Supreme Court. So we're going to look at a few of those cases that have actually shaped the United States, and we're going to look at their long-lasting effects on the United States. But first, I want you to look at a few terms that will kind of help you understand a little bit more about the judicial branch and about government. So these terms up on your screen are going to be judicial activism and judicial restraint. So the big difference between there's a huge difference between these two. They're actually pretty opposite. So judicial activism is going to be the personal views of the person ruling in the court, that they are going to use their personal views along with the Constitution to make something constitutional. So, in a negative way, this is called legislating from the bench. So, legislating from the bench just means like you don't agree with what is going on, and you are calling. It's really saying that they're calling the shots from the bench. So it's like kind of calling an audible for sports, or like calling a timeout in a basketball game so that you can like recall. It's kind of exactly what it's talking about when it's talking about legislating from the bench, is that it's using your personal opinion to make something work. This is also seen in a good way. So why it's called judicial activism is because they can also be seen as activists. So these judges can be seen as interpreting the times. So, like when it came to women's rights, that was overruling um, some major biases inside the United States and some court cases that had already been established. And this allowed them to use their own personal judgment to interpret the Constitution. On the other side, there is judicial restraint. So judicial restraint is going to be when they just limit their own power and call the shots exactly how they're interpreted. They take every word of the Constitution and they rule it as such. It's kind of like an umpire calling a baseball game, if we're going to go with another sports analogy, where they know the laws and they know the rules and they are just going to call them how they see them. So those are two things to really consider when we're looking at these court cases. So if you ever hear something about judicial activism or judicial restraint, though, that is what they're talking about. They're either talking about a judge that is ruling based off of his own personal judgment, or a judge that is just ruling based off of exactly what the Constitution says. So I will let you guys decide if those are good or bad things. They both have good and bad connotations with them. So it's really up to personal decision. And I think a lot of the times it is usually based off of what side you agree with. So if they're ruling in your favor and they're being an activist, then you probably are more likely to be on their side than if they're not ruling in your favor. You would probably call for more judicial restraint. So very interesting to look at it that way. So let's look at a few court cases from the Supreme Court that have really impacted the world. Well, at least the United States and sometimes the world. So let's look at the first one. So the first one is McClough versus Maryland. This happened in 1819. What really is going to happen is the state of Maryland is going to try to tax the national bank. And what's going to happen is it's going to go to the court case and just say that you can't tax the national government or the federal government. This is really going to establish implied powers in the government, and it is going to show that the federal government does hold a higher standing above the state government. This is not how it was supposed to be set up. Remember when they first drafted the Articles of Confederation, they made it so that the Articles of Confederation actually gave the state more power, and they were actually trying to stay away from the federal branch having more power. So this really shows a lot about how, since the government had been formed, it had changed to give the federal government more power than the state government. Schoeneck versus the United States, 1919. This was pretty interesting based off of what it means to actually have freedom of speech. So freedom of speech before this was kind of a very loose term. You're like freedom to say anything that you want at this point. So what they did is they actually had a Supreme Court case ruling that if it put the United States in danger, or if it was a criminal act that you were speaking, you have the freedom to say it, but you're not free of consequences for your actions. So it's really freedom of speech, not freedom from consequences. So that's really what this was saying. And it's just saying that your civil liberties, if you are breaking the law, will be suspended. So you can say, oh, I have freedom of speech, but if you are breaking the law using that freedom of speech, or any other freedoms that are in the Constitution, you are still breaking the law. The next one is Brown versus the Board of Education. I'm sure you've all seen this one before. 1954, based off of the civil rights movement, made the doctrine separate but equal. It abolished that, so they started desegregating public schools, and they really made a way for other rights movements later on. Let's move on to the next one. So we have the New York Times versus the United States. This happened after Vietnam. So remember, in Vietnam, there was the Pentagon Papers. So the Pentagon Papers were leaked papers that showed that the reason we got into Vietnam, the Gulf of Tonkin incident, was actually a bunch of bogus, and that the government had lied to the people. So they actually ruled in the favor of the New York Times in this one, and they said that that was their freedom of speech, and that it didn't put them into the nation into immediate harm or immediate danger. So if it would have been breaking national security, it would have been a different story. But we, especially later on, we have a bunch of different newspapers that actually do post things about what's going on and do not get in trouble because of their freedom of speech. We have New York versus, or US versus Nixon. So US versus Nixon is going to really put the precedent for what is breaking the law when it comes to being a president, or like abusing your power. So this was just for Nixon after he would not give up the evidence of what he was recording. And they really made it so that if it's not against national security, and it's not going to put the military in risk, then it needs to be given up in an investigation. So Trump did the same thing in his impeachment case, where he said he wouldn't give over evidence because of national security, and nothing really came about that. So interestingly enough, we have Gregg versus Georgia, 1976. This was a change in the death penalty, so it allowed states, juries to not issue the death penalty. That it made it so that the death penalty wasn't necessary even if you convicted them guilty based off of circumstance. So states really had to redefine who was getting the death penalty. So just because someone was accused and sentenced to because of a murder trial doesn't necessarily mean they are going to get the death penalty based off of their circumstances. So like say it was self-defense and but it was still they didn't need to murder the person. Um, that would be one of those cases where it would have been up in the air, but before this they would have just tried him. If it passed, then they would have gotten the death penalty. So this changed for a lot of different states. We have Rotker versus Goldberg, 1981. So we're getting a little closer to nowadays. This rules that women are excluded from combat. So women don't need to be drafted in for the military. So women don't have to fill out the draft. But this really led to a lot of different issues. So we threw this one in here just because it led to like this really big gender discrimination battle of like, is it gender distinction or is it gender discrimination? So that'll be up to the person who's really looking at this. So I don't know if you're happy, ladies, that you don't have to be drafted and you don't have to be on the front lines in the military, or if you think that that's taking away your rights as a U.S. citizen and as a patriot of the United States. We're almost done, but Texas versus Johnson, 1989. This is, of course, this happened in Texas, but they were burning flags, and they actually ruled that burning flags was a freedom of speech, and that it didn't. It was a part of self-expression, that you can't force someone to be a patriot. You can't force someone in the United States to love the United States. If they want to speak out against the United States, they can do that, and they can burn flags. We have the Citizens United versus the FC, which was in 2010. So this was a more recent case, obviously within your guys' lifetimes. This was actually a ruling for if corporations should be able to spend money in the elections. So corporations can, we know that, we've gone over that, and they base it on freedom of speech. These are called lobby groups. We've talked about them before, but donations are going to be equal to freedom of speech. And we're going to see that in every election until this ruling gets dealt with, I guess. So these elections are just getting more and more out of hand on how much people are spending because corporations are donating and then hoping for a little kickback in the future. You know what I mean? The last one we're going to talk about is actually from 1969. It's Tinker versus Des Moines. And it was actually for students in schools. So they were wearing these black armbands during the Vietnam War that showed that they did not agree with the Vietnam War. And the schools tried to get them out of the school for that, but they saw that as a protest and they weren't hurting anyone by doing it. So it gave students freedom of speech, which I think was just a really cool case to throw in there. So it's just saying that the schools can't limit what you're protesting within the school as long as it does not collide with school standards or put the school at imminent risk of actually having problems later on. Like it can't be gang related. You can't all go around wearing red bandanas and like throwing up the Crip symbol. But this was actually a protest for the Vietnam War. So it was done out of care for their family members and care for the people around them. So that is what we are looking at today. In the comments below, you can do it in Google Classroom or you can do it in the YouTube video. Go ahead and put which of these Supreme Court cases you think had the most impact on the United States, or which one you think is the most impactful to your life in general. So let's go ahead and leave some comments on that. Maybe your classmates can comment on yours. I will also accept that. And I hope all of you have a great Tuesday. Later.